Okay, folks, according to the U.S. Atomic Clock in Boulder, Colorado, the time now is 12:30 on the East Coast. So good afternoon to all you lovely East Coasters. It's a beautiful day here in Washington, D.C. The sun is shining. The cherry blossoms have now gone past their bloom, but it is absolutely gorgeous here. Good morning to all you sunny folks out west, and we hope everybody in the middle of the country is having fair weather as well. Welcome to Animal Law and the animal research community. A couple of notes before we get started. You'll notice there's a control pane in the upper right hand corner of your screen. If you're connected to audio through your computer speakers and for some reason you lose audio, go to the control pane and you'll find a number there where you can dial in by phone. We will keep you in listen only mode so you can chat and we won't hear it. Probably a good thing, but you'll have to type your questions at the end of our presentation into the questions pane on your control panel. As per our typical policy, all your burning questions will remain anonymous. Okay, a few more comments before we get started. Putting on my FBR hat for a moment, I'd like to thank you all for your participation in Biomedical Research Awareness Day across the country. Education and context are keys to this issue. And what better way to start? Actually, I find the level of engagement that we're seeing across the country very, very encouraging. And we sincerely hope our educational materials have been a helpful addition to your event. Along those lines, stay tuned for an exciting announcement about a new resource we'll be unveiling very soon called Perceptions versus Reality, where a real practicing pediatric oncologist proudly dispels many of the common myths surrounding animal research. And for those of you who so kindly and generously sent a charitable donation to support FBR's programs, check your mailbox for our first ever professional annual report. What's the best way to communicate with us? Well, you can always send a note to info@fbresearch.org for educational materials or info@neighbor.org for public policy information and webinar information. Both accounts are continuously monitored by our staff here. And now for the main event. I'm pleased to introduce you to the distinguished Jerry Tannenbaum. Mr. Tannenbaum is Professor Emeritus at the UC Davis School of Veterinary Medicine, where he taught required courses in veterinary law and ethics from 1999 to 2013. He also taught these subjects for 17 years at Tufts University School of Medicine, where he helped found that school's signature program in ethics and values and its master's program in animals and public policy. At Davis, he also taught an undergraduate course in animal ethics for animal science and animal biology students for 8 years, and from 2003 to 2015, offered the first course in animal law at the UC Davis School of Law. Mr. Tannenbaum did his undergraduate work in philosophy at Cornell University and graduate work in philosophy at the Rockefeller University and Cornell. He was an assistant professor of philosophy at the University of California, Santa Barbara. He's a graduate of Harvard Law School and was an assistant district attorney in New York County, New York, Manhattan. Mr. Tannenbaum's primary areas of interest are animal research ethics and animal research law. He speaks regularly at meetings and conferences on these subjects. Recently, in January 2017, at the ILAR workshop on the future of laboratory animal law at Harvard Law School, and in March 2018, he gave the keynote address at the annual ICOOC meeting of Priminar in Columbus, Ohio. He also gave a talk on the subject of this webinar at the 2018 meeting of ALAS in Baltimore, and we got a ton of incredible feedback on that presentation, which is why we're doing it for a broader audience here today. Mr. Tannenbaum's recent publications include What is Animal Law in the Cleveland State Law Review, a wonderful chapter on Russell and Birch's 3 R's in JLAS, and a chapter on the key role of the investigator in P. Michael Kahn's book, Animal Models for the Study of Human Disease. Most recently, he submitted an invited article on knowledge as justification for the use of animals in research for the forthcoming bioethics issue of the ILAR Journal. That's a mouthful. To say Mr. Tannenbaum is a learned and wise man would be an understatement. I think you're all in for a real treat with this presentation, so now I give you Mr. Jerry Tannenbaum.
Thank you, Matt. Unfortunately, the older you get, the more things that, hopefully good things, can be said about you. I want to begin with an apology for the gravelly voice and the occasional cough. As you all know, the Nobel Prize for Medicine and the billions and billions of earned bucks have not yet been awarded to the person who will find the cure for the common cold. But Matt Bailey wants me to let you know that if you're one of those people, and one of you out there may be, not to forget neighbor. Okay?
Thank you.
Okay. Also, hopefully we won't have a sound interruption. When I speak, I tend to pace around and flail about. And the last webinar I gave at Davis, actually, my arm hit the microphone, which flew across the room. So they tell me that this one is anchored solidly. Let me thank Matt and Taylor and Alyssa and Rocco and the wonderful staff here at Neighbor for putting this together. And also, I want to thank all of you who are taking some time out from your day to join us. I really hope that this is just the beginning of a long and intense conversation about the issues that I'll be talking about. Okay. I want to begin with these words, these famous words of the Chinese general Sun Tzu. If you know the enemy and know yourself, you need not fear the result of 100 battles. If you know yourself, but not the enemy, for every victory gained, you will also suffer a defeat. If you know neither the enemy nor yourself, you will succumb in every battle. How did we announce it? We're having trouble advancing the slides here. Nothing.
Use that. I think get it.
Okay. Now, none of us presumably has to be reminded that this is a war. And I commend this wonderful book, published in 2008 by the late Michael Kahn and James V. Parker. It's timely today. It's an easy read in the sense that you can read it quickly. And Kahn and Parker point out the fact that there is a war. And part of the war, a large part of the war, is being battled on the legal front. And that's what I want to talk about today. Here are my aims: to identify key things you need to know about the animal rights, animal activism, legal movement, and I will explain why I want to talk about the animal rights, animal activism movement instead of just the animal rights movement, much of which is beneath the surface and is not always recognized, and then I'm going to suggest some of the things that we all can do. Hopefully we're getting better at this.
It's the mouse. It won't get over there. Wait a minute. It disappeared. It won't get there. See if you can get it there.
Bear with us one moment, folks.
Matt, you want to vamp for a few minutes while we get this thing going?
There we go.
Okay.
That was worth waiting for.
Yes.
Does that work?
I no longer can show this slide to students because, believe it or not, they don't know who this was. So, but you know, most of you know who this was. And he used to say, "Let me make one thing perfectly clear." So I want to try to make one thing perfectly clear before I start. I gave a talk on this subject a few years ago, and a laboratory animal veterinarian came up and said, "You know, Jerry, this morning I was in a really good mood, and then I heard your talk, and now I want to commit suicide." Now, it's not my purpose to get anyone depressed, and certainly not to commit suicide. However, much of the message here is not a happy one, on the other hand, I feel very strongly that there is time and there is the capability to turn things around, but a necessary part of this is to understand what some of these problems are. So here are the topics I'd like to talk with you about. What is animal law? Some basic facts about the animal rights activism legal movement, the great schism in the movement, who are these lawyers anyway, a multi-layered structure of the legal assault on animal research, and what should you do? First, let's talk about animal law. Next slide. When I taught animal law at Davis, I would begin the course by asking students to come in. One of the nice things about teaching in a law school, by the way, is you can give students an assignment before the first class. And I would ask them to write down a definition of animal law, and especially interested in learning what the students who really had not had any exposure to animal law thought animal law was. And this is the kind of definition that I would routinely get. Use of the law to advocate for the rights or interests of animals and against traditional uses of animals and legal principles that allegedly harm and oppress animals. And I call this the advocacy definition. And I looked up the definition of animal law on Google, of all things, and last year, in October, I found the following definition. Animal law is the study and practice of law relating to animals. As an animal lawyer, you apply your country's legal system to speak for animals and their human associates and allies. You might be contesting animal exploiters, defending animal rights activists, and campaigning for the legal status and rights of animals. In other words, for many people, animal law is animal rights law, is the use of law to advocate for animals and to advocate in specific kinds of ways for animals. And I know that a number of you out there in webinar land, when you think about animal law, this is what comes to mind. However, there's another definition. It's an objective definition or neutral definition, and very roughly, it is the area of law that deals with animals. Much more neutral definition. And this definition is coming on strong, and I hope that I've had something to do with this. This is the original definition up here from Google, and just a few days ago I went back to Google to see if anything had changed, and I was astonished. I have no idea where this came from, and I'm happy. An animal lawyer is someone who is involved with legal cases involving veterinary malpractice, wrongful death, well, we'll talk about that in a bit, tainted pet food products, dog bite defense cases, discrimination, landlord-tenant disputes, estate planning, purchase disputes, animal cruelty, and other animal-related legal issues. In other words, according to this definition, not yet. Go back. Can we go back? Nope. Okay. Sorry, I gave Taylor the wrong signal here. You see, according to this definition, one can be on either or many sides of the issue and still be an animal lawyer and still be involved in the practice and in the study of animal law. Now, so these are the two definitions, and they're battling it out in the legal community and also among advocates, people who are interested in animals. I think it's fair to say that the advocacy definition predominates in law schools and is promoted by most instructors of animal law courses. However, an increasing number of lawyers, some of whom represent animal users, accepts the objective definition. Now, it's not surprising that the objective definition is gaining adherence, because one of the great things about the legal system, at least for lawyers, if somebody is that if somebody is on one side, somebody else is going to need a lawyer to represent the other side. Good for the legal profession. And as animal activists and animal rights advocates have been using the legal system for their aims, lawyers are now being retained to argue the opposite position. Now, the advocacy definition is bad. It's very bad. If a law school wants to teach animal law, it must teach animal rights or activism law, if this is what one means by animal law. If lawyers want to practice animal law, they must practice animal rights or activism law. So law professors, law students, and lawyers who do not accept animal rights activism are locked out. And this is bad because it deprives us of debate, discussion, development. It makes it difficult, if not impossible, for people who do not advocate animal rights or activism to study and develop a coherent body of law if, by definition, animal law is advocacy law of a certain kind. Now, what should the research community response be to this battle? You ought not to accept the advocacy definition because it makes it more difficult to understand and employ the law to defend animal research. And I believe that a number of so-called animal advocates want a general acceptance of the advocacy definition for this reason. You should not speak about animal law versus animal research, but animal rights or activist lawyers versus animal research. And if I can self-promote a bit, I have what I think is a pretty decent law review article, free of cost. I've been told that it's an excellent remedy for insomnia, but actually it's a very good article, and I would recommend it to you, and it makes some of these points.
We will send that out to the group after the webinar.
Yes.
Okay, good.
I have it.
Good.
Next slide, please.
Next slide. Now, here are some basic facts about the animal rights and animal activism movement. The ultimate aim of the movement, is the termination of the use of animals in research as part of the termination of all uses of animals for the benefit of humans or animals. The movement believes there is interconnectedness, and this is very important, among various kinds of human oppression, in quotes, of various kinds of animals, which it believes stems largely from the distinction between humans and animals and the legal status of animals as property. The legal status of animals as property presupposes a distinction between humans and animals and is an essential part of the movement. The legal arm of the movement is not just the tip of the spear, but much of the spear, in part because of the enormous influence of the legal system in American society. If you've read ahead in the materials, you already know how many lawyers there are in this country. If you haven't read ahead, don't, and I'll tell you in a few minutes. It's a shocker, as they say. In part because the movement regards the law as the foundation of, and therefore the solution to, the human oppression of animals. However, this all means that research is often an indirect target of the legal arm of the animal rights activism movement because of alleged interconnectedness of forms of alleged human oppression of animals. The legal arm of the movement does not always address animal research directly, and this is why those of you who are involved in animal research and advocate for animal research should be, and in fact are interested in how the animal rights activist legal movement targets other uses of animals. For example, no chimpanzee research going on at the moment. And yet, in fact, an arm of the legal part of the animal rights activist movement are still focusing on chimpanzees and attempting to prove in courts and sometimes in legislatures that, putting it roughly, chimps are people too, persons as well. Now, why are they doing this? Part of it has to do with their belief that chimps are people too, But part of it also has to do with a plan, a tactic. That if one can declare that certain species of animals are persons, then one can apply this doctrine, this legal doctrine, down to other species of animals, to non-human primates, and further and further. And so this is an important part of developments in animal research law, even though it no longer involves directly animal research. Famous case, and you have the website to an article in which lawyers are attempting to have a horse sue its owner for neglect. The horse actually would sue the owner and presumably be awarded some money. This too has nothing to do with animal research, but if animals can sue, if they're persons, if they have what we call legal standing, then that will have definite effects on animal research. This is a case, so there are hundreds of these cases. Woman awarded $45,000 in cat death. A Seattle woman whose cat was mauled to death by a neighbor's dog was awarded $45,000 last week in her wrongful death lawsuit against the dog's owner. Wrongful death is an important concept because traditionally we apply it only to human beings. When the law recognizes animals as people, Illinois is only the second state to adopt a law that would consider the well-being of animals in custody battles. Animal lawyers say that they are a step forward, these laws, in the recent push to recognize the rights of animals, not as property, but as sentient individuals entitled to certain rights of their own. Now, there is, in my view, a definite tension here. Why shouldn't how an animal would fare in a divorce, as a result of divorce, be taken into account? Why shouldn't it? On the other hand, there's the danger here that if we regard animals as people, that will have unintended, and for some people, intended consequences. This is no longer the homepage of the ALDF, the Animal Legal Defense Fund, but was a few months ago, where they were featuring SUNY. Cats and kittens are being exploited and killed in the name of science. Next slide. And you can see from their recitation of their focus areas that animals used in research are a very important part of their work, but only part of their work, but that in fact almost everything that they do would have ramifications for the use of animals in research. Okay. We also want to talk a bit about the necessary societal substrate. Laws don't exist by themselves. They usually are not passed, and certainly are not followed, unless society is ready for them and in favor of them. So non-legal developments in public attitudes often must precede legal change. And let me give you an example. The Non-Human Rights Project has been active in lawsuits in Connecticut, for example, attempting to have courts declare elephants as persons and get them released from zoos on the traditional writ of habeas corpus. And one of the newer cases involves Happy, the Asian elephant, housed in the Bronx Zoo in New York. And this is a poster that the Non-Human Rights Project has. I have the right, this is the elephant speaking, to liberty, to socialize with members of my own species, to live in an environment similar to my natural habitat. Now, some of you, I suspect, and at least two of you I know, because I can see you, are giggling at this. And one reason, and only one, to giggle, is that what? It ain't going nowhere. Next one. But one can say, I think, the following. Maybe it will. And maybe one reason it's not going anywhere is that society is not ready for it. Now, when I say that, I don't mean to say society would be good for society to be ready for it, but maybe society is not ready for it, and maybe what Stephen Wise and other lawyers who are taking this approach ought to be doing, and probably are doing, is to seek societal change in order to make the legal change they want more possible and likely. This is an old poster from the Ringling Brothers at Barnum and Bailey's circus. I taught a number of years at Tufts University, and one of the donors, great donors to Tufts, was Barnum. And Barnum's favorite elephant, Jumbo, in fact, was stuffed and displayed in one of the halls at Tufts University. No longer, of course, you know. But Jumbo and the elephant were the key, the center of the Ringling Brothers Barnum and Bailey circus. And as you know, first, Ringling Brothers did away with the elephants, and then they did away with the circus. This is the first, or at least the very early, package of Barnum's animals, animal crackers. Notice the bars. Notice that these animals are what some would say, what Stephen Wise would say, the lawyer, in solitary confinement. Here's a more recent package. There are bars, but they're not as prominent. Notice each animal is accompanied by a young'un, and apparently there's great happiness and frolicking going on among Barnum's animals. And this is the new, greatly improved package. This is the new package. And notice there are no cages. There's no confinement. Note that the creators of this package were smart enough to keep an elephant between the lion and the zebra. But there's another thing that's odd about this. I'll let you think about that for a second. Notice they're still Barnum's animals, right? Which means they still belong to Barnum. Now, Barnum, I understand, no longer has anything other than elephants, but at some point, perhaps soon, Barnum's would no longer be on this package, and we would simply have animal crackers, and all kids and adults would get to eat their animals with milk and chew them up without calling them Barnum's animals. Now, the point I'm trying to make is that these are changes. These are changes that may, in fact, affect the willingness of the law to make changes that would greatly affect the legal status of animals and the ability of certain kinds of animal research to proceed. Now, who are the rights activism lawyers? And I will explain why I use this cumbersome term, rights activism. Where are they? Well, we have the HSUS, Humane Society of the United States Litigation Unit, 13 lawyers located in Washington, D.C., New York, San Francisco, and Seattle, and a network of over 1,000 pro bono attorneys, that is, attorneys working for them free of charge. The Animal Legal Defense Fund has 9 lawyers as of October 18, plus the use of outside lawyers, and the PETA Litigation Unit, 4 lawyers. And this is the cover of a magazine that lawyers read, some lawyers anyway, which features the PETA Legal Department as the best legal department of 2017. Where are they? They're in advocacy groups. For example, the Non-Human Rights Project, which has 2 or 3 full-time lawyers. There are solo practitioners, small law firms dedicated to animal rights activism law. There are a few associates and partners at large law firms and some law school professors. The Animal Law Committee of the American Bar Association tends to be activist and rights-oriented, and a number of state and local bar association and animal law committees that espouse animal rights activism law. How many are there? I would venture to guess fewer than 75. Pro bono, it's hard to say. The HSUS claims 1,000 work for them. Seems like a large number to me, but maybe that's so. According to the American Bar Association, as of May 2018, there were 1,338,678 licensed active attorneys in the United States. Doesn't include me. I'm licensed, but I'm not active. That is an astonishing figure. And the point I want to make is, can we call this a movement? We're not talking about a lot of lawyers. Now, there's something good and something bad here. What's good is, this is a very tiny slice of the American legal profession. The bad thing is that these folks have and are gaining more expertise in the kind of law that they practice. Now let me talk about the great schism, the great split in the animal rights activist legal movement, which I think a number of people in the research community are not aware of, and it's important to understand. The first component of this large movement certainly was the animal rights legal movement. The group, Lawyers for Animal Rights, was founded in 1979. It became the Animal Legal Defense Fund, the ALDF, a number of years later. And at least initially, according to this group, animal law is animal rights law. An essential part of animal law and animal rights law is gaining legal personhood for animals and the abolition of the property status of animals and the abolition of all forms of exploitation, which would mean essentially any use of animals for the benefit of humans or other animals. This is a quotation from Joyce Tischler, the grande doyenne of the animal rights movement, a very important figure. She founded the ALDF, still around. What we now call animal rights law or animal law began when attorneys consciously considered animal-related legal issues from the perspective of the animal's interests. Notice, animal rights law and animal law are synonymous. When they began to view the animal as the de facto client, and where the goal was to challenge institutionalized forms of animal abuse and exploitation. And you will not be surprised to hear that one of these institutionalized forms is the use of animals in research. Okay. Next slide. However, there has been a split, a very significant and important split. In a very important law review article, Jonathan Lovehorn, who was the director of the HSUS litigation unit and is now at Harvard Law School, I will say more about Harvard in a few minutes, wrote the following: "This society's support for granting non-human animals meaningful rights is exceedingly low, and it is likely to remain so for a good long time. Animal lawyers can make a good start by jettisoning our own revolutionary rhetoric, such as granting animals personhood or otherwise eliminating the property status of animals. It is an intellectual indulgence and a vice for animal lawyers to concern ourselves with the advancement of such impractical theories, while billions of animals languish in unimaginable suffering that we have the power to change." Lovehorn, I'm going to go back to this. Lovehorn, apologize for my crackling voice here. Let me take a little drink. Lovehorn expresses what I think a growing number of people in the activist movement now believe, that personhood may come, some would say should come, but it's not coming soon. And so what this pragmatic approach focuses on are attempts to improve animal use and treatment in research, agriculture, entertainment, and for wildlife animals. For many, I think most of the people who take this approach and who consider themselves part of this general movement, rights, personhood, etc., is the ultimate aim, but the view is taken that it's very far in the future. Now, let's look at the rights approach. Still very active, very, very active. What are some of the positives for the general movement? Well, first, it attacks fundamental legal doctrines, and if successful, will lead to massive and quick changes. If, for example, the courts say that the writ of habeas corpus can be issued and enforced for certain species of animals, if certain species of animals are persons, that will have an earth-shattering consequences in a whole number of areas, including animal research. On the other hand, this approach does not result quickly in change, because this is a very significant legal development, and the law makes these developments very, very slowly, and it can backfire with just one or few negative court decisions. For example, Stephen Wise and the Non-Human Rights Project are arguing in the courts of Connecticut at the moment that certain elephants, are persons and ought to be granted certain rights. They have argued in the New York courts that chimpanzees also should be granted the status. It's quite possible that one of these cases will reach the Supreme Court of one of these states, and the Supreme Court will say, sorry, never, over our dead legal bodies, will animals ever be persons or subject to the writ of habeas corpus. And this could kill a great deal of what the animal rights activist movement is about. And also, this approach does not appear to be going anywhere. It garners a great deal of publicity, but thus far with very little legal success. What about the activist approach, the more pragmatic approach? Positives for the movement. It can quickly result in some changes. It can take advantage of shifts in public attitudes and respond to public concerns. For example, if something comes up, some conspicuous misuse of animals in research, let's suppose, the movement can pounce on this and try to get a change either in laws or regulations, and they might succeed. But there are negatives. Perpetuates general animal uses the movement has opposed. For example, in the food animal area, Gary Francione, a professor at Rutgers School of Law, who's one of the leading thinkers of the animal rights legal approach, has opposed legal initiatives that would improve the lives of animals used for food. Why? Because he says, and I think he has some reason to say so, that if you improve the lot of these animals, people will be happy with how they're treated, and people will go on eating their meat, their eggs, their milk, and so forth. And it leaves untouched fundamental principles such as the property status of animals, which the movement generally wants to change. So, what does all this mean to the community? Well, first of all, you should know about it. You should know about it. It's very important. We have to continue to pay attention, but not place complete reliance on your responses to claims about personhood, fundamental rights, etc. Because I think it's going nowhere. And the victories are important victories because if they were defeats, they would be catastrophic defeats. But this is not the whole story. The schism is good from the point of view of the research community because it divides the labor of the rights activist movement. Sometimes they're actually at each other's throats. But what's bad, and I think is happening, the likely failure of the rights approach will lead to an even larger number of lawsuits and proposed legislation and regulations. In other words, because there's not an attempt to change the fundamental core of the law, the movement goes after this activity, that activity, this activity, that activity, this lawsuit, that lawsuit. And what happens as a result is you will need to devote more resources to legal battles because there will be so many more of them. Okay. Now, something about what I call the multi-layered structure of the legal assault on animal research. Now, if we look at the top of this slide, we talk about legal battles. And I have a number of layers that are underneath the legal battles. Here are some examples of legal battles. state research animal adoption laws and bills, open records lawsuits, necessity legislation, that is, certain kinds of research can only be done if necessary, species-directed federal bills, and here are some examples, and municipal legislative initiatives. These are at the top. These are legal battles. These are the battles that have to be fought. They have to be anticipated. They have to be won. This is what Neighbor does, for example. And without these fights, there could be serious, as you know, incursions on the ability of you to do research. However, this is just what's at the surface. It doesn't come from nowhere. Directly under the surface, contributing to these legal battles, is what I call legal theory and pedagogy. And I'm talking here about law schools and law school courses. Animal law courses in the United States and Canada, there are 200 accredited schools in the U.S. Excuse me. And you can see from the slide how the number has progressed, now 167. And I would say of those 167 courses, fewer than 10 are non-activist oriented courses. I used to teach one at the University of California, Davis. It was, in fact, one of the most highly enrolled electives. And when I retired, I was replaced with Joyce Tischler, the founder of the ALDF. I'll say maybe a bit more about that. So that's one fewer non-activist oriented courses. The point I want to make is that there are very few courses. And by non-activist oriented courses, I do not mean, from my own point of view, courses that take it upon themselves to promote animal research, animal agriculture, or animal anything. I'm talking about courses that go right down the middle, try to be objective, and then encourage the students to argue whatever position they think the law ought to take. Many, perhaps most of these courses, are taught by outside lawyers who are members of the Animal Legal Defense Fund. Why is that? One reason is that very few full-time faculty at law schools want to teach animal law, and the ALDF comes forward with people who would be happy to teach it. Of full-time faculty who teach animal law, most are animal rights advocates, and the vast majority of these courses aim to train rights advocates or activists, future professors, lawyers, and judges. Bob Barker, is he still alive, by the way? Is he still with us?
So. Yeah.
I think he may be. I don't think he runs the show anymore. Somebody else does. The former host of the Price is Right, is that the one?
Yes.
Gave $1 million gifts for the study and teaching of animal rights law to each of these universities. Bob Barker, a very smart man, in doing so, he could have given all of the money to one university, but what he did was he gave enough to each of these so that they can't have a full-time endowed chair, but they have enough to keep the deal going. But many of the law school courses are not taught yearly. Most have very low enrollments, and many law school administrators don't care who teaches animal law as long as somebody will do it, and regard it as nutty because of the advocacy definition. Now, this is good and this is bad for research. It's bad because the courses that are taught tend to be patently anti-research. It's good because if many law school administrators really don't care who teaches animal law, if the research community can find some more or some proponents of research who will teach objectively, and I mean that sincerely, there's a strong possibility of improvement in the situation. There are 5 law reviews now. Law reviews are very, very important. For those of you who are not familiar with the legal world, just as you got to publish in academia, in law schools, faculty have to publish in law reviews, and there are now 5 law reviews that are devoted, strictly speaking, to animal issues, and by and large are activist or rights oriented. There are 2 notable programs: the Lewis and Clark Center for Animal Law Studies at Lewis and Clark Law School in Portland, They collaborate with the ALDF, and they are, I still believe, the only law school that offers a Master of Laws in Animal Law. And there is the Harvard Law Animal Law and Policy Program, a very wealthy and well-developed program that sponsors fellowships where lawyers can come for a year or two to study certain kinds of animal advocacy law, conferences, legislative, and policy studies. So, we have the legal battles, contributed to by the legal theory and pedagogy, but this also doesn't come from nowhere. What's underlying the legal theory and pedagogy, what's going on in the law school, is what we can call animal studies. Animal studies. Maybe you don't know about animal studies. You will in a few minutes. Sometimes called human-animal studies, sometimes called critical animal theory. That word critical is critical. Those of you at universities know that it's used in a number of different areas. It includes differing general approaches. Peter Singer, for example, the utilitarian, who rejects the theory of animal rights, is included. Animal rights theory, feminist animal theory, and postmodernist animal theory, which I'll talk a bit about in a few minutes. There are different approaches, contradictory, inconsistent approaches, but they're universally opposed to animal exploitation, which includes the use of animals in research. Increasing in popularity in colleges and universities across many disciplines, primarily philosophy and sociology, but increasingly in English, history, comparative literature, and psychology, an increasing number of professors and graduate programs in animal studies. Dozens of books. I mean dozens of books. If we put on the table in front of me the stack of books that have been published defending animal research, I have a very bad back. It would be a stack that I could carry around because it's got 2 or 3 books, maybe 4. Dozens of books, hundreds of journal articles, new academic journals, scores of college and university courses. If you know a college student or are paying money to a university or college for a college student who wants to take liberal arts or social sciences, a course in animals, he or she will likely take 1 or more such courses. And for your enjoyment, here are just 2 examples of college catalog descriptions. From Hofstra University, Contemporary Ethical Dilemmas. The red is my contribution to this. Do atrocities of slavery, genocide, extreme misogyny, and animal exploitation have anything in common, such as massive scale or institutional structure? What do you think? What do you think? What do you think this instructor thinks about that? If so, how does that matter ethically? If not, why are some crossed? Should grave kinds of immorality be analyzed separately, and on what terms? This is a bit longer. I won't read the whole thing from Wittenberg University. I'll just read the... Well, all right. Increasingly, social scientists are focusing on the ethical, environmental, and social consequences of human treatment of other animals. Going down a little further, for example, some scholars argue that cultural practices that define and use non-human animals as food contribute significantly to various forms of environmental devastation. Human health research indicates that high rates of heart disease and cancer in many cultures can be attributed to the consumption of animals. Others suggest that human perception and treatment of non-human animals are related in significant ways to such enduring problems as racism, sexism, and violence against vulnerable groups of people. This course will examine the causes of human exploitation of other animals and the issues that frame the animal rights debate. That's only a sampling, a very small sampling. I'm an old guy. Well, my wife doesn't like me to say that. I'm older than most. And I remember going to college, and I remember taking philosophy courses, and I remember never, ever being subjected to courses in which the instructor promoted a certain viewpoint. It just wasn't done. That's not the case anymore. Animals and Society Institute is a very important group. You really should become familiar with it. They have a very interesting website. And it is to animal studies what the ALDF is to animal rights activism law. It's very, very important. They also have fellowships. They have seminars, a book publication program, online video presentations, 2 journals, and they're assisting the development of college courses that are intended to promote and express not just advocacy, but advocacy that targets certain uses of animals, including animal research. Well, there's a fundamental layer, higher education. I've got the question marks here because it's not clear to me yet what contribution higher education or certain aspects of higher education are having to animal studies, leading to legal theory and pedagogy, and then the legal battles. So I put that in quotation marks. But something to note, and I will try not to be too inflammatory here. I will be calm. I will be calm. This is not a safe zone, but I will be calm. In the old days, remember courses in Western civilization? They were required at virtually every college and university. They're gone now. They're gone. Western civilization is gone as a concept and a subject of required courses. Now, that's important for a number of reasons, it seems to me, but one of them, from the perspective of the research community, is that human exceptionalism, that is, there is a distinction between humans and animals, non-human animals, and that in certain important respects, humans are more important and of greater value than animals, is a key tenet of Western civilization. And also, the fact is that today's universities are usually often exclusively secular. And it's a key tenet of most religious doctrine and thought that humans are superior in certain respects to animals. So when you strip away Western civilization and you strip away some of the religious thought and doctrine that in fact have been important contribution to Western civilization, you have an environment in which certain things can happen. And one of them I not so generously call oppression studies. Some people call them victimhood studies, which is even less generous. But this is so-called critical race, critical ethnic, critical gender studies, which are becoming ever more popular at colleges and universities. And, I mean, these are complex areas, but essentially the studies begin with the view, or quickly adopt the view, that there's serious oppression based on race, based on ethnicity, based on gender, sexual orientation, whatever. Also, postmodernism is becoming increasingly popular in colleges and universities. This is, again, another complex issue. Postmodernism derives from certain philosophers in France and Italy, but very roughly, very, very roughly, it's the view that truth and knowledge are defined by those in power who oppress other people. And then there's something called intersectionality, which is the view that various kinds of oppression reflect the same values of the oppressors, so that gender oppression is related to other kinds of racial oppression, ethnic oppression, and they're interconnected, and there's intersectionality. And so the view is that in dealing with one kind of oppression, one must of necessity deal with other kinds. Now, there are attempts being made by proponents of animal studies to get animals and animal oppression, really should be in quotation marks, included in intersectionality. Some of you may be familiar with Carol Adams' book, The Politics of Meat. It's a very important book. it's important to read. It's an old book and really can't be part of a recent development. But Adams argues that that eating meat is related in important ways to the patriarchy, right? That is, men oppress and dominate women, and that is related in Adams' view to people oppressing and dominating animals. And this would be an example of a kind of intersectionality. But thus far, with little success, very few of the academic proponents of some of these views and of intersectionality seem to be interested very much in animals, in animal research, for example, but could succeed. And if it does, animal research and other animal uses would be included and attacked in a wider range of courses and disciplines, which would expand and strengthen anti-research attitudes among college graduates. Okay, so what are you going to do about all this? First and foremost, continue to fight the legal battles, lawsuits, legislation, and regulations. The battles have to be fought or they'll be lost. Identify and strengthen societal attitudes that can preclude rights activist legal victories. And here a great example is FBR's Love Animals Support Research campaign, because showing people who have pets and love their pets that animal research is important for their pets and for them, right, is a way of strengthening societal attitudes that will make it difficult for rights activist legal principles to be accepted. Recognize the need to address what is happening below the surface. Learn about animal law in general and animal research law in particular. And I'm hoping to contribute to some of this in the future. We need to, all of us, need to know more about the particulars about the law, about the legal system, about how it deals with animals and can deal with animals. Support or participate in efforts to address the legal and ethical sources of animal rights activist law. Collaborative, sustained efforts are needed. There may not be many lawyers who devote their professional lives to rights, animal rights, or activism, but they're having an effect. People in the research community need to collaborate, to understand this is a serious problem, that sustained efforts are needed. Don't delay. Time is running out. It may run out someday. I hope not. But it really is important for everyone to be involved in this area. And here is our friend Sun Tzu again. If you know the enemy and know yourself, you need not fear the result of 100 battles. If you know yourself but not the enemy, for every victory gained you will also suffer defeat. If you know neither the enemy nor yourself, you will succumb in every battle.
Which brings us to questions here in the sick bay. Jerry's on the upside of a coal, I'm on the downside, and we will soon see what Matt and Alyssa look like. But first, oops, I need to advance the slides here. Yeah, advance it. But first, don't be shy. Remember, we're always seeking suggestions for the future webinars. And just send those to info@neighbor.org. And save the date, July 10th, 2019. It will be the 7th edition of Q&A with the USDA. And this time we will be joined by Deputy Administrator for Animal Care, Bernadette Juarez, and Dr. Cody Yeager, who's a supervising animal care specialist. And note, it's on a Wednesday and not a Tuesday. So mark your calendars now. And now we can open up the questions box.
All right. Well, thank you so much, Mr. Tannenbaum, for your profound perspective on this issue. I think it is extremely needed at this point.
I have no objections to what you just said, Matt.
Oh, good. Good, good, good. And we're going to try to undock our questions pane. You may want to try to redock it and then undock again. We do have a few questions. I know many of you have got to hop off because we're sort of at the end of the hour. But if you can stay, we will, I think, Jerry will graciously try to answer a few of your questions. So bear with us as we get these questions open. Why don't you just redock it? Okay, and just maybe scroll and we'll try to. There it is.
There we go.
All right. Okay, so far, here's our first question. An animal has not been able to sue. Is the opposite also true? I.e., no animal has ever been sued? Very interesting question.
Yes, it is. This is an area of controversy within the movement. Let me give you an example. Human babies can sue people who harm them. If, for example, a physician incompetently, negligently damages, or God forbid kills a baby, the baby can actually sue. Now, the parents maintain the lawsuit. But the baby cannot be sued because the baby is not sophisticated enough to be responsible for its own actions. So it is conceivable that the law would come to treat animals, any kind of animals that could sue, as human babies so that they could sue but not be sued. So it's not an inconsistent position, although some people would say, well, if they can sue, why can't they be sued? But there's a good response, I think, at least a consistent response to that. But so far, no. So far, animals cannot be sued. Now, in medieval times, not only could animals be sued, they were put on trial. And there's a number of very interesting books that describe how, for example, if a bull rampaged through a town, they would put the bull on trial and hang it or kill it. But we don't do that anymore.
Fascinating. Are the animal law courses at law schools open to hearing other perspectives? How can we insert ourselves into these courses so that our side can be heard?
The courses really vary. Some of the instructors, even instructors who take a position, are better than others at inviting people. And I know a number of people who, on the list of this webinar have actually given presentations in animal law courses. And it's important. It's important that the research community become involved, and perhaps we can do something to facilitate this process. It's definitely important.
Yeah, I've actually participated in animal law courses at 2 different law schools in Chicago over the years.
Well, we certainly need more of that. You showed a website of an organization we should be familiar with, and I must be honest, I don't think I was very familiar with that group. Where does ASI get their funding? Do you know?
I know they have a lot of funding. I don't know. One could find out. They're a charitable organization. One could find out.
Well, presumably they have to file a 990 report.
Yeah.
So we'll take a look at that. I'm very interested.
But you ought to take a look at that. And for example, they have a series of videos. Peter Singer's on there. A whole bunch of people. There are 5 or 6 minute videos in which people address certain aspects of animal advocacy. Definitely an important group.
Do you think our system of IACUCs and the approach of self-regulation and self-reporting of animal concerns will be viable going forward in the future? Kind of a loaded question.
And I could respond cheaply by saying it's not the subject of this talk. I mean, this is a very, very large, certainly much larger issue than I can handle now.
Okay. On to our next question.
No disrespect intended, but it's just a different kettle of fish, so to speak.
Do you think it's important for those of us who support research to also resist calls for quote-unquote rights for other animals, such as agricultural animals?
Well, in a word, yes. Yes. I think that I'm uncomfortable with a hard and fast animal rights, animal welfare distinction, which, if you've read some of my old stuff, some of you may know about that. But there are ways of advocating for the interests, and I can use that word, of animals without certain kinds of rights. But because this is interconnected and of a piece, really, there is a danger here. But again, we'd have to look at specific issues in specific ways.
So you have a fan who writes, have you written any more books since veterinary ethics, animal welfare, client relations, competition, and collegiality?
And I see who sent that. Thank you. I will not identify you. I have not written books, but I've written a whole ton of articles, and I would be happy to send anyone. It was interesting about that book. It actually was the first book published, I believe, in any language on veterinary ethics. We went through 2 editions. A very good book, even though it was published in 1995. And the publisher, whose name I will not utter, informed me that they couldn't do a 3rd edition because they would have to put it out in a manner that was too expensive for veterinary students or anybody else to buy. And I think Bernie Rollin, who has a couple of editions of his book, I think he's at the end also. We take different approaches, clearly, but thank you very much for that comment. I'm very, very proud of that book, but I have some other things I've written since then.
So how would you say the concept of One Health fits into your legal view of this area?
Oh, that is very interesting. And that is something that I've actually started thinking about. And that's not a way of evading, well, I guess it is, but it's not meant to be a way of evading the issue. One Health is supremely important, as not just the author of this question knows. And One Health, in fact, provides a very powerful argument in favor of animal research, because it will and has affected and improved the health both of humans and animals. And there are a number of ethical issues in One Health. I've contributed the entry on veterinary ethics to the 2nd edition of the International Encyclopedia of Ethics, which will be coming out. And I talk about some of the ethical issues in One Health. But I think that One Health is a tool, maybe that's not the best word, but it's a tool that the research community should use to promote humane animal research and effective animal research. And of course, one of the arguments that's been made for One Health is that in certain kinds of circumstances, we may not have to induce certain conditions in animals. They occur naturally. There may be a reduction in the number of animals used, and maybe effective ways of treating both human and animal conditions. But I see One Health as one of the major opportunities and promises, not just of animal research, but of animal research ethics.
All right, our next question is actually excellent. Do you think that maybe there's a strategy being played out by the animal rights lobby to attempt many lawsuits, knowing that the people they're suing have limited resources? Ergo, they win by basically draining the resources of their enemy.
Well, that's an old tactic that predates the animal issue. When I practiced law, after I was a prosecutor, I practiced civil law for a couple of years, and it was really distressing, the extent to which a party could win by losing, by draining the resources. And this is a serious issue for animal research, for NABOR, for example, and for anyone who wants to defend a lawsuit. Yes, I mean, any dollars that are taken away and efforts that are taken away from the research can affect and impact the research. So yes, I think there are some. Now, when I talk to some of these people, they really believe in their cause. Many of them, they understand that they will probably lose in the short term, but in the long term, they feel that they would win. But I'm afraid to say that one of the things that the legal profession should be least proud of is the extent to which litigation, especially, aims at wearing the other party down financially and emotionally. I mean, I used to specialize in veterinary malpractice, for example, and very often the insurance company would propose to the veterinarian, let's just settle this darn thing. You don't need the aggravation. We'll throw some money at them so they get the money. They don't win the lawsuit. So, yeah, I think there's some merit, a lot of merit to the question. Yeah.
Do you think most people who support animal rights / animal welfare really oppose most uses of animals in research?
Well, there are differences, right? There are definitely differences. It is certainly the case that the old or traditional animal rights activists oppose all of it and eventually want to do away with all of it. Andrew Rowan, a former colleague of mine, he has a very important book. I don't know that Andrew is out there or not, but he's still at the HSUS. But he wrote this, Of Mice and Men, I think is what it is. Very, very, very interesting.
Mice models.
And man, it's an old book, but it's still very worth reading. He says at one point in the book, there's really no disagreement that animal research ought to be ended. Everybody thinks it should. The only disagreement is about tactics and timing, so forth and so on. I don't subscribe to that at all. But so there are some people, who want to make sincere changes. Just as there in the food animal area, there are meat eaters, lots of meat eaters, who think that we ought to be treating a number of these animals better than they're now treated. They're not opposed to the use of meat, use of animals in food. So I think I think it would be unfair to condemn everyone who suggests improvements in animal welfare for laboratory animals to be against animal research in general. But it's certainly an important question.
I think the next question is for Alyssa to answer.
Yeah, I think so. I'll read this, Alyssa, and then you can fill them in. Is NABOR or other organizations active in going to high school science teachers? Materials they need to understand and teach their studies, the contributions of animal research to medical advances.
So, I think it was last week or the week before, the Foundation for Biomedical Research attended the National Science Teachers Association Conference, in which I believe over 9,000 science teachers, kindergarten onward, attended, and I had the opportunity to join FBR, and we actively participated in handing out our materials to all 9,000 teachers and engaging in conversations of how they can use our materials in their classroom.
Okay, it appears the traditional response by the research industry has been to try to ignore or distance themselves from activist activity directed at them. This seems counterproductive. Is there a more appropriate response recommendation?
My response to that? Stay tuned. Yes, we have to work on it. Very important question, by the way. Very, very important question because, as they say, the devil's in the details. There are a number of different things in different areas that can be attempted, I think.
Would you happen to be familiar with the legal case in Iowa where the Endangered Species Act was leveraged by the Animal Legal Defense Fund? Would this approach potentially be able to be used with research facility animals?
I am not familiar with the case.
That's the case involving, I believe, a small local exhibitor zoo who, using the take provision of the Endangered Species Act and how the animals were being cared for, and they sued on that basis.
Yeah. That's interesting because the Endangered Species Act, unlike the Marine Mammal Protection Act, the Endangered Species Act is clearly anthropocentric.
Yes.
And does not have a great deal, at least in the statutory language, that is concerned with the welfare of the animals. The Marine Mammal Protection Act, which was passed the same year, does indeed focus on the welfare of the animals.
Okay, let's go to the next question. Knowing that each law school course is different,
Yes.
which institutions are teaching courses objectively? If so, I'm wondering if it might be worthwhile for the research community to come together to financially support those programs, teaching objective courses. Maybe that could begin a movement to gain some ground with support of objective teaching.
That's an interesting question, and I think it bears and deserves further work. I'm no longer teaching in a law school, at least not at the moment. Rick Cupp at Pepperdine probably does. I think Mamie Foster might at the University of Virginia, and there are a couple of other names that I can think about. But by and large, there are not a lot of them.
We got one more that just came in, or the one previous we didn't. I don't think we answered.
This is new.
Yeah, can't quite make that question out. Let's see the one prior to that. See if there's another.
There's something broken up with the way it was typed in.
Okay. Well, it looks like maybe we've answered them
Yeah.
all. If you
Yeah.
want to scroll down and see if maybe there's one more late question that came in. No, I think we're good. Oh,
Scott Hager.
we've got one more here. Okay. The anti-research activists are actively attempting to change laws that on the surface do not appear directed at research, but had the intention of impacting the conduct of business, i.e. shipping,
Yes.
adoption requirements. What should our industry be doing to protect our ability to legally and ethically conduct animal research?
It's a brilliant question. Requires answers. These are all very, very serious questions, and I think what I'm calling for is for folks to get together in a collaborative way and sustained way to think about how these approaches can be taken. Absolutely.
Which Neighbor is doing with the transportation issue, and has tried to help states with the adoption issue.
Yeah, I mean, there are a number of things that I think we're all doing collectively. We may not be doing them all together at the same time, but increased awareness is extremely important, and I think a good first step is what we've done here today. Having Jerry Tannenbaum come in and explain, his views, which he's been able to develop over many years. I think you all should listen to what he has to say. And I know there are many people who couldn't join this webinar, so we will have this recorded, and it will be available hopefully by Friday. So if you know somebody who missed it, we hope that you'll have them tune in. In addition, I think we're going to be looking forward to working more closely with you. So this is not the last you're going to hear from Mr. Tannenbaum with Neighbor.
And by the way, let me, perhaps I shouldn't point this out, but I will anyway. My email address is on the handout, and I'd be happy to try to answer questions if you want to email me something.
Looks like we have one late comment or question that came in. While waiting to gain rights for animals, it seems that new bills introduced by anti-vivisectionists, if adopted, will hinder what can be done. For example, what's happening with the presidential hopeful on Cory Booker's legislation, the Primate Protection Research Modernization Act of 2018.
Yes, I mean, these are the kinds of efforts, what I call the legal battles, that are pragmatically oriented, pick out certain particular issues that certain people think the public will be favorable to, and go at those, for sure.
And just, sort of as an update on that piece of legislation, numerous advocates of science have been into Mr. Booker's office, including us, to discuss the problems with that legislation. I would like to be able to say that the staff there have decided not to pursue this any further. I cannot say that. It seems that they are still determined to reintroduce something along these lines for this particular congressional session. We don't know what that's going to look like yet. But at the moment, I think the scientific community is sort of keeping their powder dry until we see what that looks like if and when it comes back out. But I will say that I was heartened to see the kind of response we saw from the community on this legislation. How many, Alyssa, institutions in the United States depend on primate work?
More than 170.
Right. So defies logic that a presidential hopeful would also want to have over 170 premier research institutions opposing them for legislation like this, but we'll see what happens. I think we have come to the end of our presentation.
And the perfect ending is the final comment there. Thanks, Jerry. Brilliant and interesting as always.
Bravo. Thank you
Adios.
so much.